If you have another topic of your choice that you feel needs, some attention, yeah, let me know. So we have, I'm hoping you have your notes with you, because I don't know, I'm not able to share today. Yes, Moses, kuna shida?
Nilikuwa na suggest kama tunaweza fanya maybe negotiation ama hiyo next topic.
Niachane na alternative dispute resolution. Aya. Negotiation, mediation, arbitration.
Yeah.
So that will take us around 30 minutes actually, yeah?
Sawa.
It's okay.
Yeah.
Sawa, I'll do that now. So let me okay. Let me get my notes so that I'm able to be very fast. Give me a few minutes, a few seconds, not even minutes. Give me a minute, I get my notes, please. Where is it? Just a minute. So I got it. I hope you're following. I hope you're still there. I was trying to get my notes. So I think now we can continue. So alternative conflict resolutions, commonly referred to as ADR, refers to all those methods, that are used to solve a dispute outside the court, So note that, So the issues, there are disputes or conflicts that are better solved outside the court. Of course, we know there are those that have to be solved outside the court. Even the government will not allow people to solve them outside the court. But there are those issues, let's say family issues, such as, let's say, land, such as grudges, hatred. So sometimes if such issues are, if the family members, maybe family business, sometimes you realize family business wrangles, you realize if such cases are taken to the court, sometimes the court can advise the members to try what you call alternative dispute resolution, so like trying to solve these issues outside the court, and they're highly encouraged, yeah, or even maybe a dispute between an employer and an employee. Sometimes the two can be asked to, to look for ways such as, let's say, negotiation or whichever, or even mediation. So we say, I'll just start from ADR. So we say, of course, ADR, there are benefits of alternative dispute resolutions. So one, we say they are cheap and quicker compared to court case litigation process, whereby one needs to hire a lawyer and maybe pay other fees, and incur the cost of going to the courts and all that. Yeah. So we say ADR is cheaper compared to litigation and quicker. We say it's friendly, flexible, and nicer than civil exchange. We say it tends to promote, the process is usually considered informal, yeah, because it does not follow, the laid down rules, yeah, or law, like the litigation process, yeah, or the civil exchange. So the process tends to be somehow informal and tends to promote privacy. Reason why we say it promotes privacy, ADR, is because you realize if you have two parties conflicting and they decide to have a dialogue, of course, they have the dialogue among them or between themselves. But you realize with court cases, of course, the public is usually allowed to, to go to court and listen to the ongoing cases. So, but you realize with the ADR, that is not usually allowed. It is usually maybe the parties that attend these resolution process are usually the parties affected, and maybe a neutral third party. So you realize with this ADR, the parties are usually assured of what? Privacy, and tends to put the parties at what? Ease. Of course, there's no much tension, like the judge will rule the case in favor of so and so. With ADR, it tends to put the parties at ease, which brings about better resolution of conflicts. With ADR, we talk of conversation and cooperation. Normally replaces what? Replaces conflict, while informality empowers the process, yeah? So with ADR, conversation and cooperation normally replace what? Replace conflict. With ADR, we say it tends to empower the parties, yeah? Maybe to understand what caused the differences or the dispute, what they need to do to solve such a dispute in case it arises in future, and the measures they can take to minimize occurrence of such maybe disputes. It is said to be more efficient than the conventional adversarial system. So it is more efficient in terms of what? Time and money. We have another one. The other one where we say the parties are given an opportunity to decide on the choice of location, time of meeting. So in short, they have the control over the whole process. So that is another point whereby we say the parties are usually given an opportunity to decide on the choice of what? Location, time of meetings. So in short, they are able to control the process. And because they're able to control the process, we say all this combines ensures confidence in the entire process. So you realize with ADR, the parties can agree. We are going to meet in this hall at this time. And yes, such things, yeah. But you realize with litigation process, you realize that court cases, the parties do not have the power to decide on what? To decide on the location, or even the time to meet. Of course, that is controlled by the courts. We have conflicting parties enjoy the assistance of neutral third party. Of course, that is another advantage we talk about. The conflicting parties normally enjoy the assistance of neutral third party. Of course, and these neutral third parties are usually experts in the subject of their on the subject matter of their dispute. Also, you see that now they have the option. They have the conflicting parties are usually privileged to select a third party that will facilitate conflict resolution process. But remember, of course, the neutral third party must be an expert in the area must be an expert of the conflicting subject matter. Let's say the subject matter is about business, commercial business, or maybe land, or maybe marriage, such, yeah. So the neutral third party must be an expert in that specific subject matter. So, of course, the charges of a neutral third party are usually not very high compared to the litigation process, yeah. Those are some of the and the other one, which is also important to look at, another advantage, we say the proceedings and records of the awards are not open to the public. So the proceedings, nobody knows what happens during those meetings or the proceedings of finding a solution, and the records, whatever is concluded after every meeting, and the awards are not open to the public. They remain known by the two parties, the conflicting parties alone. Another one, we say there's usually a positive working relationship. The other one, another advantage we talk about is that these long-term compliance of the agreement reached by the parties. Note that this long-term compliance, the parties will comply more to what to the award given or what has been agreed upon, far more than the government agencies imposed outcomes. So it is said that ADR tends to promote long-term compliance. Like if they agree, after, let's say, ADR, maybe the parties agree that maybe they're conflicting over land, and then one party is told, now you're going to move from that land and move to the next one. You realize that happens. It's said the compliance, you'll find that the party that was told to do that will do exactly that, because probably they argued the points and found that was the best solution, unlike the government imposed outcomes, like the rulings of the court. So ADR is said to be more beneficial because conflicting parties tend to comply more, and even for a longer period. Not like where someone steals chicken or something is taken to the court and afungwa, then after he finishes his term, comes back to the community and commits the same offense and is taken back and forth, So with ADR, we say there is long-term compliance of the reached agreement. The other one, we talk about appeals are easily discouraged, especially where there is provision that such awards should be final. Sasawa. So with the ADR, we say that appeals, in court cases, appeals are very common. Of course, after the ruling, someone can always appeal to challenge the decision and maybe get a better hearing. But you realize with the ADR, appeals are easily and highly discouraged, especially in cases of arbitration, where you find in arbitration the arbitrator gives an award or makes the final decision after hearing the case. The last benefit of ADR is that we say it tends to preserve the relationship between the disputing parties. You've been given the example of what? Divorce matters, yeah? Where children are involved, maybe in divorce matters, as much as even after the parties, the couple divorces, you realize that, of course, children remain there, and they belong to the two parties, yeah? So instead, of course, with ADR, it tends to ensure that such a relationship between such a couple is not destroyed. Instead, it is maintained, yeah, or preserved, so that the two can continue taking care of the children. But sometimes you realize when such parties, like a couple decides to just have a divorce, yeah, of course it's important to have a divorce in the court, but you realize sometimes ruling might be very hurting to one party. Maybe the husband is told to be remitting maybe let's say 60% of his salary. So chances are high he will hate his wife and maybe sometimes his children, because he'll see them as a threat, like you having all my money as much as I work hard. So with ADR, it tends to preserve such relationships, yeah. Maybe it will, in issues such as, again, maybe a family issues, disputes between family members. Maybe someone has picked an item of the neighbor, ama ng'ombe za brothers zilienda kwa mwingine, one brother ikaenda kwa mwingine ikakula kitu. Of course they are encouraged to look for to solve such an issue out of court. Maybe landlord tenant issues, business partners, because it's important to preserve the relationship. So note that. We have a few critics of the same ADR. We talk of course, ADR does not provide the solution to all disputes, yeah. There are conflict situations where court trial is most appropriate. Let's say, issues maybe in a case involving murder, yeah. Of course, such cases are better solved where in the court, yeah, not using ADR. We have another one. ADR processes rob the public an opportunity to follow case proceedings. Like you said, ADR does not allow the public to go into that venue or room where the proceedings are going on and listen. So it robs the public that opportunity to follow case proceedings. Of course, where there is ADR, maybe mediation is being used, arbitration, or even negotiation. Such cases, such processes cannot be highlighted, let's say, on TV. Like you see with some court cases where you see they decide to do what? To publicize that, yeah, to the public. Sometimes we see another disadvantage. We say there is failure of accountability because of the adherence to privacy of proceedings and awards. So there is failure of accountability. Like you cannot really tell what was discussed, how, when, and what was the final agreement. Unlike court rulings, yeah, where you find, of course, you're able to know what the final ruling was. Like after the judge listening or the magistrate listening to the case, they make a ruling, they give a final award or ruling word or final verdict and say, do this and do this. Sometimes with ADR, there's failure of accountability because of its nature being too private. And the last one, we say there might be power imbalance between the parties. You realize sometimes one party might have more resources than the other. So, and you realize sometimes resources, let's say finances, you find, or maybe one person is more powerful than the other, and you realize, or one is more learned than the other. So you realize one party that has more resources has better bargaining powers than, where there is that power disparities. Then we continue, unless you have a question there.
Yeah, we can proceed.
Good. So the others will be able to move very fast. Negotiation, I'll not even go into details now that I've already explained what the others are. I'll just highlight to make you understand the differences between negotiation, mediation, and arbitration. With negotiation, negotiation will simply be said to be what? A dialogue, yeah, between disputing parties with an intention to solve a dispute and reach an agreement. So it's just a dialogue intended to resolve a dispute and reach an agreement. Or it can be said to be bargaining for any kind of advantage. Again, it is said to be the primary method of ADR, and it can be done to satisfy individual needs. Negotiations are said to be daily affairs in business, legal proceedings, government affairs, and other such activities. Of course, in negotiation, the term negotiator is used to refer to what? A person well versed with negotiation skills, such as a peace negotiator, hostage negotiator, diplomats, or brokers. So, of course, there must be negotiators from both sides, yeah? Yes, so who negotiate and must and or should reach to an agreement that satisfies the needs of both parties, yeah? Yes, so we have different types of negotiators. We said example, a peace negotiator, hostage negotiator, diplomats, or brokers. So generally, negotiation will involve the parties involved in the disputes. For example, let's say there is a dispute between Kenya and maybe Somalia. That is just an example. So the two governments can opt to use what? Negotiation to resolve the conflict or the dispute. Yeah. So what they do, each country will send its representatives, yeah, to do what? To carry out the negotiations. Or let's talk of maybe two business having issues. They can always negotiate. So this sends their negotiator and this one sends their negotiator. Or maybe hostage negotiator, maybe is one example that has been used in Kenya, whereby you find maybe Al-Shabaab have done what? Abducted some Kenyans along the border, yeah? So you realize maybe the Kenyan government can send its negotiators, and maybe the other group has its negotiators, and they can always talk to see whether, they can have a dialogue until they resolve the dispute. That is just an example. It has worked, even that one in the past, although sometimes it does not always work, and especially where someone's life is being threatened. If the two do not agree, let's say in a case of hostage, you realize sometimes people still get killed. But of course, negotiation is supposed to work and satisfy the needs of both parties. We have aims of negotiations. This one I believe are simple to understand. One is to bring to the open issues that are problematic, stating those problematic issues openly without being judged or being angry or being defensive. The other one is making those concerned listen actively and evaluate facts. The next one is reach amicable solution. And the last one, amicable solution using information presented, and the other one, reaching a solution that satisfies both parties. We have the process of negotiation. I'll just highlight it. You prepare, preparation, discussion, clarification of goals, negotiation towards what? Note that win-win outcome, yeah? And then we have agreement, and then we have implementation of course of action. If you have any question regarding that, you'll ask before we end the lesson. We have techniques for successful negotiation. We have one, both parties must aspire to respect each other. The other one, both parties must recognize there's a problem and be able to define that problem. What is causing this dispute? Is it money? Is it affair? Is it boundary? Is it, I don't know. The both parties must be able to recognize and define the problem clearly. Yeah? The other one is that they must seek a variety of solutions. Of course, seek a variety of solutions. Maybe we can try option A, B, and C to solve the dispute. But again, they have to do what? Settle on the most appropriate solution. Sawa? Or the most suitable alternative, rather, the most suitable alternative to solve the dispute. Of course, for them to be able to get this variety of solutions, hautoangi kwa kichwa yako tu nasema my instincts tell me if we do this, we'll be able to solve the problem. Of course, that is not what is done in negotiation. Of course, for you to be able to develop these variety of solutions or alternative solutions, you need to get this information from where? Books, magazines, articles, experts in the area, you know, conduct research, yeah, brainstorm, conduct a lot of research to be able to have good information. Ndio isikue try and error, unajaribu inakataa kila wakati. Of course, for you to develop these solutions, you need to be really informed. Then another one is technique. Another technique is collaborate. Which means working together does not mean giving up or giving in to another person's demand. Two or more individuals can agree that disagreement exists. However, they can also agree to put aside their anger, frustration, resentment, and egos in favor of working together for a solution to a common problem. So all negotiated work is completed by consensus. A negotiated solution is reached when everyone has given up something and gained something, and to gain common benefits. Of course, collaboration will be encouraged in other approaches, yeah. But of course, there is no harm in negotiation when someone gives up something, yeah, to gain a common benefit. There's no harm if both parties give up their interest, you know, to be able to accommodate the other party. So, but of course, the idea is to have a win-win outcome. The other one is that the parties must be reliable. That means they must committed towards working together and finding a long-lasting solution. The other technique is that negotiation must always aim to preserve the relationship. Sawa. We say there are no good guys or bad guys, winners or losers in negotiation. Negotiation aims at what? Is based on equality. So there's no good guy, there's no bad guy. There's no loser, there's no winner. All of them, it should aim at bringing an outcome of bringing out the win-win outcome. So those are some of the techniques. We have results of negotiations. So we say the agreement or solution reached needs to be fair and just, to be acceptable to both parties, to reach a compromise that both parties are left feeling good about what has been decided, to restore good feeling and relations between parties involved. We have negotiation is more successful when both parties do what? When they recognize and value their relationship, participate actively in the process, accept and consider each other's perspectives. The other one, separate personality from the issue involved. So you don't take your attitude with you there, knowing ukisema huu ni mbaya, hata nikimwambia nini hawezi skiza. So you separate personality from the issue. And the other one, work together to develop a solution everyone can accept. You have the tips for successful negotiation. You have them there. It's just a repetition of what you've said. Communicate clearly, respect each other, recognize and define the problem, seek solutions from a variety of sources, collaborate, be reliable, and aim to preserve relationship. We have mediation. I think I can continue. Mediation normally use a third party to solve a dispute. It uses a neutral third party to solve a dispute. This neutral third party is referred to as who? Mediator. A mediator acts as a confidant to both parties. So he acts as a confidant, a reconciler. Of course, the reason of having a mediator is to facilitate the process resolving the dispute. So both parties meet together with the mediator, raise their issues. Once they raise their issues, they do what? The mediator listens, and then when he listens, the two parties can now discuss the issues, until they are able to arrive at a consensus or at an agreement. Sawa? So note, the mediator does not make a final decision for both parties. He only facilitates. He only facilitates the process. And that's why we say he acts as a confidant to the parties as well as a reconciler. Of course, he aims at making the parties reconcile, but he listens, makes the parties talk, air their grievances, makes the other party listen, makes the other party feel what is unfair, and what needs to be done. And then at the end of the process of mediation, they can do what? The two parties should be able to leave, having reached at an agreement. So generally we say mediation has a structure, timetable, and dynamics that ordinary negotiation lacks. So like we said about ADR, the process is private and confidential and possibly enforced by what? By law, because the parties can be asked to go have mediation by the court, Though we say participation is typically voluntary. We'll see why we say participation is typically voluntary in where? In mediation. Because if you compare it with arbitration, sometimes the participation is not voluntary, sometimes in mediation. It is normally sometimes imposed on the parties by the court. But we say participation is typically voluntary in mediation. What else have I not said? We say mediators use various techniques to open or improve dialogue between disputants, aiming to help the parties reach an agreement. Of course, mediators, again, are usually trained in various fields. I think one of the mediators that is commonly known by Kenyans is the late Kofi Annan, who helped, what was his name? Kibaki and this guy, Raila, reached at an agreement after the 2007-2008 post-election violence. So some of the issues that can be solved using what? Using mediation are like family matters. You can see them there. Example, divorce, separation, financial disagreements, prenatal issues, parenting, all that. Maybe workplace issues such as wrongful termination, workers' compensation, discrimination, harassment, grievances, labor management. Maybe public disputes such as environmental issues and maybe land use. We have commercial such as maybe difference between landlord and tenant, homeowners association, contracts, medical malpractice, among others issues. Yeah, we have forms of mediation. We have 3 forms. We have right-based mediation. I hope you still following.
Yeah. Following.
Okay, so I hope I'm not very fast. Maybe I know I can talk very fast sometimes. Good. We have forms of mediation. We have right-based mediation, interest or needs-based mediation, and then we have therapeutic mediation. With right-based mediation, yeah. So this kind of mediation is based on rights that disputants will have in court, and likely they get the same results as that of trial in court. Then we have interest or needs-based mediation. This approach looks up at the needs of what? Parties, and then intervenes. And we have therapeutic, which focuses more on what? Problem solving skills of the parties involved. We have stages.
Pardon.
I repeat.
Results. Yeah, results based.
We have rights-based mediation. This is based on what? Rights that disputants, yeah? You know, giving the disputants the rights that they will get in court. Yes, the rights that they will get in courts. That's what they normally get, more of the same thing. Then we have interest-based mediation. So this kind of mediation or approach aims at, solving the needs specifically of the parties. And then you have therapeutic, which generally focuses on what? Problem solving skills of the parties involved. Then we have stages of mediation. You can see them there. I said you should have your notes with you. We have discussion. It begins with discussion, just like negotiation, accumulation of information. The person who accumulates information is the mediator. So he accumulates information by what? Listening to both parties, yeah? And both parties are supposed also to listen to each other. The other one is developing the agenda and discussion strategies, and then generating movement, agreeing on the way forward, whether they are going to compromise, whether they are going to collaborate, whether they are going, whichever method, approach or style will help. And then they agree on that. And then escaping to separate discussion sessions. The last one, solving the conflict. We have merits of mediation. It's more of the same as merits of ADR, actually. There's no much difference. We talk of costs. I'll not explain because I'd explained. Unless you don't understand, seek for clarification. We have confidentiality. It ensures that the parties involved are able to control the discussions and proceedings. We have compliance. Remember, we said there's long-term compliance when ADR is used. We have mutuality, whereby parties to mediation are typically ready to work mutually towards what? A resolution or towards resolving their disputes. Then we have support. The disputing parties have the support of a neutral third party. And then we have demerits, where we talk about what? Sometimes we have one party feeling threatened by the other. We said this could be caused by what? Maybe resources, yeah? One is more learned, one has more money and such. Number 2, I don't like that point, even if I have it there. We can just ignore that, sorry. We have the other one. Sometimes we say there is increase in the acting out, yeah? So that is, acting out is like indirect expression of anger, fear, or frustrations. Yeah, there is that increase of acting out. Like people can stomach their anger so much, or frustration sometimes, or fear. We have sometimes important needs might be ignored or might not be acknowledged. And we say the last one, sometimes it lacks the skills necessary for what? Peacemaking or peacemaking. Yes, or lack of awareness of the skills the parties do possess. We go to the next area, arbitration. Arbitration, yeah. So arbitration, again, is a way of resolving disputes out of court. But again, you realize that it uses a third party, a neutral third party, who is referred to as an arbitrator. Yeah. Now, the difference between these and mediation is that you realize that the disputing parties sometimes are, let me use the word forced, are forced by the court to go for arbitration. Yeah. To go for arbitration. Now, what happens in arbitration is that you find the arbitrator tends to hear the evidence or the story of both parties, and thereafter renders a decision, which is usually called what? Award or an award. And this award is expected to be binding on the parties. Yeah. So it is said, the whatever decision after whatever the decision arbitrator makes is usually binding or is usually final. So that is the difference between mediation and arbitration, because you see in arbitration the mediator does not make the final ruling. He has to push the parties until they agree on the outcome. Yeah. But with arbitration, of course, the arbitrator renders the final decision, which is usually called what? Award. And it's expected to be binding on the parties. So once that award is made, the parties have to abide by that. So it is said arbitration is similar to adjudication, but the major difference is that, unlike litigation, arbitration is usually done outside the court. Sawa? But of course, arbitrators are usually highly trained, yeah, on matters of law. Of course, they are experts in law. So that's why they have the privilege of listening to what? Cases and rendering their decision, which is usually binding. We have two forms of arbitration. We have binding and non-binding. Binding and non-binding. So when we talk of binding arbitration, we say arbitrator's decision is normally binding and final, and no appeal on such decision is allowed, unless, except in cases where there's proof of what? The arbitrator behaving or favoring maybe one party. So binding arbitration, you find that the decision of the arbitrator is final and one is not allowed to do what? To appeal. While in the non-binding arbitration, we say a mandatory process, often called what? Court annex arbitration, must be resorted to in some jurisdiction than going to court. Each party has the opportunity to present proofs and arguments of arbitration, which is less formal, procedural than court adjudication. So that is the non-binding, yeah. So whereby it's a mandatory process, yeah, whereby the parties disputing are sent to see an arbitrator, yeah. So they are asked to go see an arbitrator. So again, each party has the opportunity to present their proofs or their stories or evidence and arguments at arbitration, but the process is usually formal, not usually less formal than that of court adjudications. So those are the two most common types of what? Arbitrations. We have examples of arbitrators, yeah, in our communities. But of course, yeah, a few, but of course, sometimes you have the most learned arbitrators. Of course, someone like chief elders or heads of families and communities, yeah, can also be referred to as what? Arbitrators. Like you find sometimes people go to courts to present their cases, maybe against their family members. And then the court, the judges, the magistrate maybe listens to the case and sends the family back to the chief, to see our elders, to see if the chief can help solve that problem, yeah. And usually the chief's decision is usually binding, it is usually final. So we have that. We have conciliation. I look at this one and the last one. Conciliation is an attempt through which parties are helped to reach their agreement by a third party. So the aim of having a conciliation is that we have is just to help the parties solve the conflict using who? Using a conciliator. There's nothing much about conciliation. So we can see that in Kenya, conciliation has statutory backing by an act of parliament. So sometimes when there are issues, disputes, these parties can also aim at going to see a conciliator. We have the counseling. Counseling is that kind of counseling that yeah. So sometimes whereby we have a relationship between what? A counselor and a client. So counseling is therapeutic, yeah. It's therapeutic. So that's why it said generally uses therapeutic techniques, yeah. Such as a particular line of questioning may be useful in mediation. So the role of a counselor in solving the dispute, is just to listen to the stories of the both parties, use the counseling techniques to help the two parties solve their problems. So you should be able to now see the differences between mediation and counseling. Of course, they are key. Yeah? I hope you go through that on your own. And then we have all these types, all these other types. We have, let's say, talk of shuttle diplomacy. Shuttle diplomacy, of course, this method of solving the disputes is usually used on parties who cannot agree to face each other, yeah, whereby maybe the parties feel like I cannot face so and so. So normally they use shuttle diplomacy, whereby there's a neutral third party who is sent back and forth. He goes, because the two parties cannot meet. So what happens is that this third party, who is a messenger, yeah, is used and sent to this party, listens to the story of this party, then goes to the other party, then leaves the other party, goes to the other party, until the two parties are able to find what? To find a solution. Then we have litigation, whereby courts typically impose binding decisions on the parties, yeah. And which one else? This one, the last one, which is early neutral evaluation as a method of dispute resolution. So this one is whereby there is usually an evaluator who acts as a neutral person to assess the strengths and weaknesses of each party and discuss the same with parties jointly. Sawa. Yes. So this party in early neutral evaluation is whereby there's an evaluator. He listens. He should be neutral. He assesses the strengths and weaknesses of each of the parties to discuss the same with parties jointly. So he listens to one party, the other party, and then discuss the same issue with the conflicting parties together. And then they're able to make maybe a final ruling thereafter. Allow me to stop there, please.
That's okay.
That's okay.
Yeah.
Okay. I can see. Oh, you are able to mobilize all these Moses. I can see Kamau is here and Felix. How are you, Felix? Felix, umeweka mute. Unmute yourself. Ama ulishaenda kulala? Aha, eh? Martin, how are you? No, bado. Oh, nice to hear your voices. Where is Martin? Martin, you still with us? Martin. Okay, seems like I don't know. Okay, I hope you followed. We've been together for almost 1 hour. So thank you for joining. Yes, and I hope you learned. Okay, I've seen your message, Martin. So what you do, make sure you sit for all your cards and assignments as you wait to start your exams on 17th. Any comment or any question?
Yes, please, Madam.
Yes, ask.
Yes, I was asking. I'm asking. This NDRs. In some cases, we have seen the mediation has failed. What happens in such a case when the mediator tries, but the two parties cannot be able to agree, or they agree and then later on they
disagree? So if
they backtrack to their
old behaviors, now they have to look for maybe resort to finding another option, yeah, such as going to, let's say if it's a case where they can go to the court, they go to the court. If it's in maybe an issue of affecting two countries, yeah, they can still go to the highest court, yeah, in the world. If that is the only option. Sawa.
Okay, Madam.
Yeah, you can have a nice time.
Same to you.
Okay.